Welcome to Lexpert TV. In May, the government of Quebec introduced Bill 96, an act respecting French, the official and common language of Quebec, which proposes significant amendments to the Charter of the French language. Today, I'm joined by Alexandre Fallon, a civil litigator and partner at Osler, Hoskin Harcourt LLP in Montreal. Today, he's here to discuss the impact of these proposed amendments on labor and employment law. Hello, Alexandre, and thank you for joining us.
Hello, thank you for having me.
First of all, what are the current requirements for job advertisements, and how would the Act change these?
So currently, companies that wish to advertise for job positions that are open to Quebec residents must post those positions in some manner in French. So there is a baseline requirement that the job posting be in French, but there's no real guideposts around how that needs to be done. And so basically our position and our experience has always been that as long as you have it out there in French on one forum, you're compliant with the Act. The Bill 96 proposes to change that by providing a test and saying that when you do the postings, it has to be on the same forums as your English language postings, or on forums that are equivalent in terms of their reach. So that will require some analysis by companies and saying, if I'm doing, for example, I'm posting on LinkedIn, I'm doing that in English, I can't get away with just posting it on a platform that has less visibility for the French posting. If you're doing the English posting on LinkedIn, you're going to have to come up with something that is proportionally as broad distribution for the French version, which practically speaking probably means bilingual job postings when you go through forums like that.
So that would potentially mean more work for employers?
Yes, I think so. And we can think of, for example, companies that have careers pages. Oftentimes those career pages are global. And so they many cases do not have the practice of putting a French version on their own career page. That might have to change under Bill 96, and that could then beg the question of, does the career page itself then have to be bilingual in terms of its user functionality? So there are some wide-ranging impacts for companies for sure.
And how would the Act change contracts of employment, either for new or for existing employees?
So for existing employees, I would say from outside of a situation where there's an amendment, the only change is that as the Bill 96 goes towards stricter requirements for providing employment contracts in French and backing that up with the possibility of enforceability issues if you do not comply, which is a new concept under the Charter that hadn't been the case previously. There's a transition period for existing employees whereby if their current employment contract is not in French, they will have a period of 1 year after the bill is enacted to require their employer, request from their employer that they receive a French copy of their employment agreement. And that French version will become the operative or enforceable version. So that's one possibility. So HR departments shouldn't be surprised if those requests start cropping up in the next 12 months. That's provided for under the Act. In respect of new employees or amendments to employment agreements, what is changing is that as soon as there are components of the employment agreement and any documents that are incorporated by reference into the employment agreement, as soon as some of those, the standard right now is to have English versions. And oftentimes we'll put a clause in there at the end saying, the parties have expressly agreed to contract in English. Reliance on that clause will no longer be possible unless you first provide the prospective employee, or in the case of a renewal or an amendment, your existing employee, with a French version of all of those standard form documents. And if you fail to do so, then you will be in a position where the employee will have an argument in respect of the enforceability, and will also have, and this is the other novelty under the Act, a private right of action in respect of seeking potential damages for not having respected the right of the employee to work in French, which will be a broader right under Bill 96, but also as an individual, because the Bill 96 proposes to incorporate the Charter of the French language into the Quebec Charter of Human Rights and Freedoms, there could also be a claim that's made under the Quebec Charter of Human Rights and Freedoms by the employee for damages, including punitive damages. So there's the consequences and the risks are much more significant under Bill 96.
And how would the Act prohibit practices with respect to French-speaking employees? Will it expand protections with regards to discrimination of unilingual French speakers?
Yes, it definitely does. Currently, the only private right of action that an employee or prospective employee has in respect of the charter of the French language is in respect of hiring and promotion, basically. So situations where an employee or prospective employee feels that they did not obtain a job or a promotion because of a requirement to speak a language other than French that the employee feels was not operationally warranted. They currently, under the Act, have a right of action in front of the Administrative Labor Tribunal to contest the hiring and promotion decision on that basis. But that's pretty much it. Under Bill 96, essentially the employee or the non-compliance with this right to work in French by a company, so not ensuring that your employee is able to work in French, can give rise to action by the employee or a complaint by the employee in front of the CNSST. So essentially the Labor Standards Board, who can then bring the matter forward to a conciliation process and ultimately on to the Administrative Labor Tribunal. And what that does is essentially placing the right to work in French alongside all of the other prohibited practices provided for in the Act respecting labor standards in the same manner as sexual harassment, psychological harassment. So basically taking any recourses against a unilingual French speaker that can be considered to be contrary to their right to work in French can be challenged in front of the Labor Standards Board in the same manner as any other prohibited practices in the labor field. So that is a significant development and expansion of worker recourses in respect of knowledge of French in the workplace.
And will the Act restrict private rights of action and recourse? And if so, would you expect this to lead to more complaints being filed under the Charter by language activists in Quebec?
Yeah, so the Bill 96 doesn't restrict private rights of action. It creates all entirely new private rights of action and in multiple different ways. And so from our perspective, the net effect of this will be to I think personally, launch a new trend of language litigation that we have not seen in Quebec because it has not been a possibility under the Charter of the French language up until now. Right now, a consumer or an employee, aside from the hiring and promotion practices piece that we've talked about earlier, doesn't have any recourse under the Charter of the French language, right? The recourse is file a complaint with the regulator, the Office québécois de la langue française, and the Office québécois de la langue française will take it from there. They will investigate the complaint. They will ask for remedial action where warranted. And if collaboration is not obtained from the enterprise, can refer the file either to the Attorney General for an injunction in terms of advertising, or to the Director of Criminal Prosecutions if the OQLF deems that a fine would be warranted in the circumstances. So the enforcement mechanism is entirely controlled by this specialized regulator. And so therefore, it allows for, remedial actions to be taken. Companies have time to address situations, right? Mistakes are made in terms of compliance with the Charter of the French language. It's an act that is complicated to comply with. But we had a regulator that understood the complexities. And, from the regulator, my experience with this regulator has always been that they want to see continuous improvement, and that if continuous improvement is being shown, then further enforcement action is unlikely. But it's a regulator that you have to work with to improve the situation of French in the enterprise. What's unfortunate with Bill 96 and the creation of a private right of action is that mechanism of understanding that companies can get things wrong, and that provided there's a willingness to fix it, no consequences, monetary consequences ensue. Well, the regulator's still there, but now you've got another constituency to deal with, and that's private litigants. because now private litigants who are not happy with a situation of noncompliance with the Charter of the French language will have a right to institute an action seeking damages, and that's immediate, right? There's no remedial possibility for companies. So I think it really increases risk significantly for all companies that do business in Quebec from that perspective. The other thing that drives this is that the what is actionable is being broadened under Bill 96 in one very significant way, and that is moving the right to be informed and served in French from the declaratory portion of the Charter into a right on which that can be insisted upon and executed upon. Because currently, there is counterintuitively no statutory obligation outside the francization process that applies to companies with more than 50 employees in Quebec. There's no enforceable obligation on a company to serve and inform Quebec consumers in French. So you are, a company who has limited footprint in Quebec, but you sell products and services in Quebec. You don't have a statutory obligation, for example, to provide phone customer service in French to Quebec consumers. Of course, Quebec consumers can complain about the fact that you don't do so, and you will receive a letter from the regulator saying it would be really nice that you do so because there's a provision in the Charter that provides for it, but that provision is only declaratory. So no enforcement action would ensue from that. They're moving or duplicating that provision from the declaratory portion into the basic obligation portion of the Act, making it such that any Quebec consumer making it such that the obligation now exists. So as soon as you do business in Quebec, you have an obligation to serve and inform Quebec consumers and clients, because it's not just a consumer focused act. It also applies to B2B relationships. You have that obligation to inform and serve them in French. And if you don't, because the private right of action is being added on top of that, the consumers or clients in Quebec who have not been served and informed in French by your company could seek damages in that respect. And that includes under the Charter of Human Rights and Freedoms, because now you've not complied with their right to live in French in Quebec in conformity with the Charter of the French language. And if they're able to convince the court that that was an intentional violation, that could give rise to punitive damages in the Charter of Human Rights and Freedoms. And so I think in that respect, we could see class action litigation ensue on that basis, and very broadly in terms of companies who, for example, don't have a French language website and yet serve Quebec clients, because that would be a breach of the obligation to inform and serve Quebec consumers or clients in French. So I do think we're going to see this new trend in litigation.
Now, the Act would create a new right under the Quebec Charter of Human Rights and Freedoms. What are the implications of this for employees?
For employees specifically, it's another recourse, right? It's another thing that can be added, onto the prohibited practices under the Labor Standards Act. And then you've got a Quebec Charter violation as well. And I think the main difference there is that your Charter violation gives rise to punitive damages if you can convince a tribunal that it was an intentional violation.
Thank you so much. That is all my questions covered. But in conclusion, is there anything else that you would like to add?
No, I think, we've talked about labor per se, but, just to say it, that, for companies or enterprises who do business in Quebec, obviously the implication, I think we've touched on it a little bit, are much broader than simply the labor component. So yes, if you employ Quebec residents, this definitely should be on your radar for the reasons that we've discussed. But really, any enterprise that sells products or services to Quebec clients, consumers or non-consumers, must be alive to what is coming, because these are the most significant changes to language laws in Quebec since they were first adopted in the 1970s, and the risk profile and litigation risk and monetary risks are being very much increased. So this is definitely food for thought for everyone who does business in Quebec in whatever sphere and with whatever target audience.
Well, thank you so much for sharing that with us. Now that wraps up today's episode. This is Lexpert TV, and thank you for watching.
Thank you very much. Have a great day.